So we have a worsening and it seems ongoing situation with our legal system when it comes to criminal conviction in cases of rape and serious sexual assault. The latest stats indicate that less than 2% of serious sexual assaults that are reported to the police result in a conviction. Less than 2%. But this isn't because prosecutors aren't doing their job or because jurors are failing to convict. It's because the vast majority of cases aren't even being brought to trial in the first place. And the problem there lies with the CPS, the Crown Prosecution Service. Now, the people in the CPS, we assume at least, have an interest in seeing justice done, but their hands are tied by codes of practice that instruct them to determine at the outset whether or not a case is viable. Their two main directives in this instance are, and I quote, "Does the evidence provide a realistic prospect of conviction? That means, having heard the evidence, is a court more likely than not to find a defendant guilty? And is it in the public interest to prosecute? That means asking questions including how serious the offence is, the harm caused to the victim, the impact on communities, and whether prosecution is a proportionate response." So the first test for bringing a case to trial is for the prosecutors to conclude that a conviction is more likely than not. Now, this has obvious flaws when it comes to addressing wider concerns about these cases. For one, it's understood that by far the greater portion of these cases involve people who are known to each other, and where often there's evidence of friendly, even affectionate interaction outside of the crime taking place. The sort of evidence that will be used by the defense to paint a complicated picture, shall we say. So those cases aren't even going to be tried. Secondly, gauging the seriousness of a crime in which there are usually only two witnesses, one of which is in denial and the other of which is undergoing some kind of PTSD, is a process that tests the limits of these codes to the extent that even an apparently strong case might be deemed untriable due to unmanageability. So the complainant, the one against whom the offence has been committed, does not have the power to insist that the accused be prosecuted. And under CPS guidelines, it is more likely than not that the accused will not be prosecuted. We have to wonder why it is that the system is set up this way. Why is it that a case can only be tried if the CPS is confident that there will be a conviction? What happened to getting your day in court? Isn't the purpose of a trial to determine the truth? We can imagine that one reason for the failure here is that lowering the barriers for trial might lead to an inundation of unconvictable cases, which we can imagine might lead to ministers and lobby groups making the claim that the CPS is wasting taxpayers' money. The CPS is on a budget, and in many cases, it's rather grim to say, justice boils down to revenue. Either way, the stats don't lie, published as they are by the CPS itself, and the situation is not tolerable. So what are the options for people whose cases are hobbled from the outset by the CPS? Well, increasingly, women have been foregoing the traditional route and opting to pursue whatever justice they can get through the civil courts instead. So this article is from Jasmine Anderson via iNews, dated September the 26th, 2019. It reads, in part, "Ms. M never thought she'd spend 2.5 years of her life suing her rapist. But when the former St. Andrews University student was told her case against rapist Stephen Coxon was not proven following a night out in Fife in 2013, she was determined to seek justice. Deflated after a harrowing court case, she decided to take an unprecedented course of action and sue her rapist in a civil court for damages. Civil action has a lower burden of proof than criminal cases. But despite that, the legal team in Ms. M's civil action called 4 expert witnesses who were not present in the criminal trial, including the surgeon who treated her. Barrister Nigel Booth explained, "There are 2 options when bringing a civil case to trial. One is suing the alleged rapist, the other is suing the CPS, to force them into reviewing the evidence and prosecuting. By doing so, the victim can expose the reasons why the CPS are not prosecuting and assess how policies have led them not to prosecute and whether that decision is lawful." In the end, she won her case. There was a decree of £80,000 and a defendant was made bankrupt. More and more women are taking this kind of action. And as a consequence of the publicity generated, women's advocacy groups have mounted general suits against the CPS for failing to protect human rights. And I'll leave a link to some of that below. Now, some might wince at the idea of this coming down to a cash payment, but as Ms. M points out, it was never about the money. It was about the law acknowledging what Stephen Coxon did to me was wrong. In addition to which, the attacker is now named, associated with the crime, and made to bear the stigma of it, which I believe is something that can function as a deterrent. It's not jail time, but I don't mean to be blithe when I say it's better than nothing. It stops these cases from disappearing, and it could lead to a revision of CPS criteria. It should be pointed out that there is a cost barrier involved in a civil suit. But increasingly, solicitors are offering a no-win, no-fee type arrangement for these sorts of cases. And that option, combined with the aforementioned lower burden of proof, would seem to make civil action at least worth consideration. Now, I can't speak to the quality of these legal services, but I will link some below with other stuff in the hope that if you or if anyone you know has been affected by this type of crime, then you might perhaps find something useful. Anyway, thanks.